and if you want to provide a right of appeal in the Constitution in exercise of constitutional powers, those have to be provided by a constitutional amendment. And if you want to provide a right of appeal in a statute, then the statute has to be amended, because this right is a creature of the statute or the Constitution. And unless the instrument which provides the appeal, or unless the law that has to provide the appeal, it is amended, it cannot be provided by implication.
Mr.
चले आप अपना पॉइंट तो बताएं ना, हम कुछ नोट ही नहीं कर रहे हैं. I'm not writing anything. I'm just hearing various queries. I mean, can you complete your submissions? Please complete your submissions, and then you can respond to all the queries.
In relation to
Zaid Ibrahim, if I may, on your reading of entry 55, would it be possible for Parliament to make a law creating an intra-court right of appeal in respect of an appeal heard by the Supreme Court under Article 185? Would that be permissible?
Your Lordship has perhaps dealt with that question, where your Lordship has even said, well, the line that, and in the end, there must be an end.
No, that's review. But I'm saying, क्योंकि आप जिस तरह entry 55 को पढ़ रहे हैं ना, review का तो हमेशा ही है. And my question is, on your reading of entry 55, would it be permissible for Parliament by an act to provide for an intra-court right of appeal in respect of judgment delivered by the Supreme Court under while hearing an appeal under Article 185? Would it be possible on your reading of entry 55?
Well, that would go against the finality principle, because right of appeal against a right of appeal. But the logic is that here there is no appeal.
Enlarge करके भी तो देखे ना, अगर ये section 5 जो है valid है, if it is intra vires, petition under 184(3) is filed, whatever happens, appeal is filed, whatever happens, there is a right of review against that.
Okay, so let me answer.
देखिए, जो intra-court appeal is original jurisdiction, never appellate jurisdiction. Intra-court appeal, so there'll be two streams. One is the original jurisdiction of the Supreme Court. When a special single judge of the High Court passes an order, that is original jurisdiction of the High Court he is exercising, provided under intra-court appeal. So that scenario may not be here at all, because 184, 185 is already there. We are only concerned with one kind of appeal, which is 184(3) appeal, nothing more.
No, I think
I understand your Lordship's question, and let me answer it.
आप जितना broadly entry number 55 को पढ़ रहे हैं, तो उसकी implications है ना?
जी.
अगर उसकी implications fail कर जाती हैं, तो that's one thing. उसकी implications alive रहती हैं. तो इसलिए समझने की बात है ना. या तो आपका केस है कि जी appellate jurisdiction में नहीं हो सकता, further ये power खत्म हो गया, मुझे तो फिर नजर नहीं आता उसमें कोई ऐसी limit.
मैं ये नहीं कह रहा. मैं वाज़े तौर पे ये कह रहा हूँ कि जहाँ तक power of enlargement hai, that exists not just in relation to 184(3), it exists. And my answer is, the line that in the end there must be an end, unless the Parliament says so. Unless the Parliament says so. That is my.
You're adding words to my words.
Yes, indeed. I'm taking the liberty of adding the words, unless the Parliament says so.
I may or may not agree with you.
Subject to your grateful, sir. Sir, if I may move to the next point, this challenge has been dressed up as an issue of independence of judiciary. There is a plethora of case law which identifies that how important, crucial, critical independence of judiciary is to our system. In relation to what constitutes independence of judiciary, what are the things that make up independence of judiciary? My Lord, I will not make your Lordships read, but I'll just cite the relevant paragraphs of a few judgments. My Lord, the first is the Sharaf Faridi case, PLD 1994, Supreme Court 105, at page 107.
Please repeat the citation.
My Lord, PLD 1994, Supreme Court 105.
At?
107.
Okay.
The second is PLD 2009, Supreme Court 879, the Sindh High Court Bar Association case, at page 1228, para 17. And lastly, PLD 2010, Supreme Court 61,
No, Supreme.
2010 Supreme Court?
page 61. This is my Lord Chief Justice Iftikhar Mohammed Chaudhary versus President of Pakistan. And the relevant page is 173, para 157. My Lord, in relation to international treaties and covenants which also define what independence of judiciary is, I have taken the liberty in my concise statement in paragraph 10, I have drawn out what these international treaties say. I will just read one sentence from there, my Lord. Independence of judiciary, according to the Council of Europe recommendations, says, the principle of independence of judiciary means independence of each individual judge should be able to act without any restriction, improper influence, pressure, threat, or interference, direct or indirect, from any authority, including authorities internal to the judiciary. This is the first definition of independence of judiciary that I was able to gather, which specifically says that from internally from the institution, there has to be independence. My Lord, repeated questions have been raised, but no one has identified which fundamental right affects the petitioners. How independence of judiciary is diluted by this law. An argument is certainly made that once we open this door and allow the Parliament to legislate in relation to even the practice and procedure of the Supreme Court, tomorrow the Parliament may make another law. My Lord, when it makes another law, it will be tested whether they are interfering in the independence of judiciary. And it will be struck down if they do so, but not at present. This law does not. My Lord, most humbly, under Article 184.3.
Zaid Ibrahim, how do you say that? Where the Act obligates the Chief Justice or the two other judges to act in a certain manner, and as was rightly pointed out by one of the councils, they are micromanaging or trying to micromanage or trying to interfere in the independence of the judiciary insofar as the Parliament will now dictate how benches are to be formed or how what cases are to be fixed by the committee or by the Chief Justice, and what would be the number of judges sitting on the benches, and how would the roster be made, and what sort of cases which go before what sort of benches. I mean, if this is not interference in the independence of the judiciary and micromanagement of the judiciary, I don't know what else would be.
My Lord,
I think this is premised. I think we should also realize that this was premised on undermining the office of the Chief Justice. Now, if the office of the Chief Justice, at least I do not read it as the same as the judiciary. I think judiciary means everyone. Chief Justice is a person. So yes, it is premised, but if I use the term independence of judiciary by saying Chief Justice, then we should use the word independence of the Chief Justice and not use the word judiciary. And then the argument goes back and forth, the same one, he's the head of the institution, so he represents the judiciary. I'm not very convinced with it. So I would say, yes, it definitely undermines the independence, or whatever better word you want to say, use not the word independent, but some other word may be better, of the Chief Justice, but not as a judiciary as a whole.
Two very brief responses. Your Lordship should give credit when this law was being debated in Parliament. The very point that your Lordship has said was also raised. And they said,
in fact, incidentally, there are two orders of this court, and the learned Attorney General also undertook to place on record the debates,
in
which
an
have
earlier,
not been placed.
my lord, in an earlier hearing, it was
Fair enough.
pointed out
So,
that
I
it
mean,
is available online.
If that order
I
had
think it's
been
been placed by
complied with,
one of the lawyers. It's available in CMA 8565. One
I
day's
think
debate
it's a
has been
good
placed.
150 pages. so-
Some parts of it have been
Acha,
placed
okay,
on the
well,
file.
all I was trying to point out that the questions that your Lordship has raised, the Parliament also grappled with it. And in my humble view, these matters can't be looked in an isolation. Let's face it, I do not know how cases get fixed. I do not know how benches get constituted. I don't know how 184.3.1 case gets presented on the 12th of April, and on the 13th of April it gets fixed.
So, Mr. Zahid Ibrahim,
This itself is a vindication of this law.
can be fixed by the Supreme Court itself.
So,
If you point
all
it
the
out
Parliament
to the
is
Supreme
saying,
Court
all the-
and the competent authority, which is the full court, which constituted, which promulgated the 1980 rules, they can revisit the rules and fix the issues.
Sir,
How does the Parliament come in?
Mr.
Order,
Zahid Ibrahim,
I
order
can
19
add-
of the Supreme Court rules, Order 19 of the Supreme Court rules says that all appeals filed in the registry shall, as far as possible, be heard in the order in which they are set down.
Okay. So
Does it
it's a
happen?
question of
I mean-
implementation. So according to you, the rules are already there, they are not implemented.
No, so-
If it is incorporated in a statute, it would ensure implementation.
It
Mr.
is
Zahid
not
Ibrahim,
incorporated in the
Mr. Zahid
statute.
Ibrahim, there seems to be a great fear regarding open door syndrome thing that's going on. So in this case, what we have to identify is whether there is a door or not. So if there is a door, there could come a law which could strengthen us, which would strengthen the Supreme Court, enhance the independence of judiciary. I'm okay with that coming in the door. But if something else walks in the door which affects my jurisdiction, reduces my jurisdiction, violates fundamental rights, access to justice, independence, I strike it down. So what's the fear? What is this open door syndrome going on?
It's a red herring.
And again, Mr. Zahid
The
Ibrahim,
main question is.
Mr. Zahid
the main
Ibrahim,
question
all
here
that,
is
all
whether
that
there
the
is a
Parliament
door.
has done.
Yeah, door is the question that will
Well,
determine.
the Constitution, for the
Zahid-
time being,
Zahid Ibrahim.
does not give a door to the executive or the legislature to interfere in the internal affairs of the Supreme Court.
So this bench has to determine whether it all is a door or not.
Mr.
What comes
Zahid
through the door
Ibrahim.
is not my problem.
I think these proceedings are a classic example of how the jurisdiction or the power was exercised by the Chief Justice. As I pointed out earlier, there are a lot more important cases which never get a turn. Now here, everyone is saying it's a good law, but everyone fears this open door syndrome, as my learned brother has stated. I view it differently. The Parliament, since this court having the power under Article 191, was even refusing to call a meeting of full court. And all that they did was to structure the discretion. They have not given any directions, and all that they have done is try to structure the discretion, which this court was refusing to do, and there were obvious abuses.
And the unstructured discretion, my lord, we can close our eyes, but the public confidence in the judiciary has eroded. And we are all invested in this.
I think, Mr. Ibrahim, if I may ask you a question, assuming that this law is, I'm looking at the practice and procedure bits of it now, assuming that this law is intra vires the Constitution, in light of this law, who is the master of the roster?
Well, according to one judgment,
No, I'm talking of the law. In light of this law, Who is the master of the
I'm
roster?
not sure where the term even master of roster comes from.
Who decides which cases get fixed where, etc., etc.?
The committee decides. The committee.
No, you're wrong. Committee is the creature and creation of Parliament. At its broadest level, this law is a claim by Parliament that Parliament is the master of the roster. And I'm asking you a question.
I apologize.
You don't have to, as already pointed out by the Honorable Chief Justice, you don't have to agree with the question. To me, this is the crucial aspect of this law. It is not whether the committee consists of 3 judges or 5 judges, or Parliament says let the full court do it, or let the Chief Justice do it. Those variations, as has been pointed out, you said it, maybe those laws will be made, maybe they won't be made, that's speculative. Whether it is speculative or not, I put that to one side. The point is, and this is the question I'm putting to you,
Yes, ma'am.
that in any of those scenarios, including the one that we have before us today, it is not the committee that is the master of the roster, because the committee is a creature of Parliament's will. Parliament has willed it into existence. Therefore, it is Parliament that is the master of the roster. Now, placed at that level, seems to me that this is directly in conflict, directly contrary to the principle of independence of judiciary. What would you say to that?
Can the master
I
of the
would
roster,
say- I would-
Mr. Ibrahim, can the master of the roster speak? I would add the word the purported master of the roster. When I became Chief Justice, and I looked at it earlier also, the existing rules of the Supreme Court of 1980 stipulate simply that the Chief Justice will constitute benches. Now, practice had developed, maybe it's in accordance with the rules, I can't find it, that every week, list of cases prepared, a list would go to the Chief Justice, this case would go to that judge, and this case would go to that judge, and this case would go to that judge. I have discontinued that practice. This is not even the job of the Chief Justice. This is the job of the registrar. They can be given broad outlines, first in, first out being the general principle. Then there can be fast track cases, election matters, naturally election matter will become redundant after a certain period of time, bail matters, etc. But to see even the cause list of the day and where it goes, I think, and this is the master of the roster speaking, please give me this power so I can use it from the existing rules. Where do I have this power? I can't seem to that.
And Mr. Zaid Ibrahim, there are no masters anymore in the world, you see. If you look around...
He always wants to undermine my authority.
With respect to the
lighter
master.
note.
No, but, so I don't see that as a master. So Mr. Zaid is that if you look at internationally, it's about time we wake up to the world, you see. We have US, UK, Germany, Brazil, Nepal, Philippines, just to name a few. There's no such thing as master of the roster. It's a collegial system that works, and that's across the board. And it's about time that we also woke up to all this, you see.
My lord,
With due respect to the master
with
here.
utmost respect, I say we need to wake up to what's outside this room.
You see if I may add to that,
And to answer,
under our system, and I don't mean to be disrespectful to anyone, masters come and masters go.
yes.
This is not a lifetime appointment.
But while they are there,
No, just a minute. One Chief Justice may have one view of the matter, the other may have another view. And those who come, and I don't mean immediately, I'm not talking of potential Chief Justices sitting here, I'm talking even way into the future, they will do whatever they want to do. But that is not the important point. The ephemeral, fleeting, whether it's 1 year, 2 year, 3 year term of a Chief Justice, of a master, if you want to put it that way, in the more traditional sense, that is in a sense beside the point. The question is, within the framework of the Constitution, separation of powers, independence of judiciary, ultimately, who is the master of the roster? And can Parliament lay such a claim and not violate the Constitution? This is the ultimate question.
But if I
Yeah,
could just
may
bring
I-
in another dimension to this, I don't know if you've looked at this new book called The Court on Trial, and they've done a data-based analysis of the Indian Supreme Court, where they say that invariably through data they've discovered that Chief Justice, if he has all the powers, he can manipulate cases. He can ensure a certain outcome. This is through data that they've presented. They've said that judges who have been dissenting, Subha Rao is one of the judges who dissented several times during his tenure as a judge, but as a Chief Justice, he never dissented because they would manage the bench. So this has been through data now established that if one person could get a bench constituted, get the judges on that bench, he could ensure the outcome. Don't you think that sort of directly hits at the core of independence of judiciary?
Of course it does. And
And
let me,
again, Mr. Zaid
I've
Ibrahim,
also read the book that I've also read the book that my learned colleague is talking about, and I look forward to having a very enjoyable discussion about it with him. But the thing is, if the principle, it's the principle that matters.
Yeah.
If one man can do it, maybe 3 persons can do it.
Your Lordship
Maybe
is,
5 persons can do it. No, if you don't like following logic to wherever it goes, then the logical answer is everything should go to the full court, but that's practically not possible.
Mr. Zaid
The
Ibrahim.
point is, the principle of the thing still stands. My question to you still stands.
I
Yes.
want to have
Please
the
answer
opportunity
that.
to answer it.
Respond करें उसको.
The answer is in two. First, I would urge your lordships to not read this law as an encroachment into the independence of the judiciary. By no stretch of imagination is this is. Even in Parliament when this was discussed, it was discussed that the bar has wanted to do this for a long time. PTI is challenging their legal counsel. Hamid Khan was cited in the debate as supporting this law. To answer your question, Parliament does not seek to be the master of roster of any.
Not a
in-
question of whether they seek to be this
Or they have
seek
not.
to- No,
Mr.
sir.
Zaid Ibrahim.
The principle that is being established is that they are. Whether they seek it or not is beside the point.
Mr.
This is
Mr.
the
Zaid
core
Ibrahim.
of the question.
I would
in-
say
Mr.
that it is
Ibrahim,
not.
in
And
most
secondly,
of,
secondly,
Mr.
in
Zaid
relation-
Ibrahim,
Just on
Sir,
the
sir,
lighter
it's an-
note,
most of the jurisdictions,
the only
the
way I
fixation
cannot
of
read
cases-
into this is to keep my eyes closed.
No, is to not chase
Mr.
shadows.
Mr.
I would say
Zaid
not chase
Ibrahim.
shadows. And just one last thing. My lord, your lordship had said that, oh, chief justices are there for 1 year, 2 years, they go, new chief justices come, and there's no, it's not you're stuck for this forever. But my lord, what do we tell people who had
No,
homes
I
in Nasla
know, I
Tower?
think, no,
What do we
sorry,
tell
Mr.
people
Zaid,
who lost
Mr.
jobs,
Zaid
employment,
Ibrahim.
That is not an
lives,
answer.
property?
Mr. Zaid
There
Ibrahim.
should be a right of appeal.
ये देखिए, let this message not go out from this court that the constitution and the laws of Pakistan are dependent on who the Chief Justice of Pakistan is. This message must not go out from this court. The laws of the constitution and the laws of Pakistan are there, irrespective of the size of the Chief Justice's foot. So let this message not go out that the next Chief Justice can do as he pleases. Absolutely not. Let that be clear that what the law is, what the constitution is not a variable commodity subject to the whims and wishes of the Chief Justice of Pakistan. That must not be so. And if that is so, that is destructive of the constitution. It is destructive of the rule of law. It is destructive of the independence of the judiciary. It is destructive of everything. If we go that far and say, oh, let the next one come, he'll retire, 25th October, he goes, the next one will come, he'll do his own way. No, absolutely not. He should follow whatever is the proper method of doing things. It's not, sorry to say, if anybody thinks in that side, Parliament, or in any other situation that he becomes all powerful, I at least will not let this institution put forward this thing, if we will do as we please, when we do. Here we have autocrats writing books, friends not masters. We don't want to even say that. I am not anyone's master. I am servant to the constitution and an abd of the Almighty. That is the place of a judge. It should remain there. It should not be variable commodity. Oh, the next justice, how will he do it? So
Mr.
I don't,
Zaid
this is a
Ibrahim-
very unhealthy sign if it is so variable, then where the Supreme Court's change laws, I mean, a law is enacted today, the way it goes up interpreted by one court, by the other court, by the higher court, by the time it comes to the Supreme Court, takes about 20 years for any law to settle. Now, if it's such a variable commodity that we sort of stump everything and we come 184.3, today the law of Pakistan is
No,
this.
certainly we look for consistency
Mr.
and that's
Zaid
what
Ibrahim,
the legal
I
system
think,
should provide. Yeah,
if
but
I'm not wrong, in most of the jurisdictions, they have adopted objective criteria for fixation of cases and constitution of benches. And they have named it as the natural judge concept. And they have done away with the concept of master of the roster. On an objective basis, criteria, and not on the basis of a discretion vested in one person.
I think it's high